Hello, and welcome to the first in a new series of risk management webcasts. Thank you very much for taking the time to join us today. I'm Charlie Netherton, the Head of Client Advisory Services at Marsh, and I'm joined by Alistair Schubert, who's our risk partner. I'll be hosting 4 risk management webcasts and 1 on claims taking place over the next 3 weeks. Next in our series is a discussion on property risk profile changes taking place on Friday. Today, though, we're talking about managing employers' liability during a crisis. For employers and employees, the coronavirus pandemic continues to bring daily challenges as we work to navigate a dynamic and evolving situation. The legal, moral, and financial duties placed upon organisations can be overwhelming as we seek to find ways to maintain daily life under the pressures of COVID-19 at home and at work. Navigating this complex and continuously changing situation is, at best, testing for organisations and is challenging due to the legal and financial implications and the risk of getting these things wrong. Today, we'll be discussing the health and safety responsibilities and liability implications associated with changes to working arrangements as a result of the COVID-19 pandemic and what organisations can do to help reduce this risk. Before we start the discussion, I want to encourage the audience to submit any questions you have through the Q&A tab at the bottom of your computer screen. Questions that you ask will be covered towards the end of today's session. If we can't get to your question today, someone will get back to you soon with an answer. I'm now going to hand over to my colleague Alistair. Alistair, over to you.
Thanks, Charlie. Good afternoon, everyone. So for my first slide here, I just wanted to start with the default position in relation to liability claims, that whilst COVID-19 is clearly a novel situation in terms of a hazard, it changes absolutely nothing from a legal perspective in terms of the responsibilities that employers are going to be expected to adhere to as it would do pre-COVID 2019. And really that's dealt with in the first 2 boxes on this particular slide, which is that you will still owe all your duties of care under the legislation outlined in the second box. Essentially, what we're looking at from a claims perspective at the moment is where may claimant representatives seek to exploit the current legislation and the current requirements around negligence to bring claims. Now, essentially, for those that are not familiar with the litigation process, a claimant will need to show 4 key things as highlighted in the first box. So first of all, that a duty of care was owed. Now, towards your employees, be they temporary or permanent, that will not be a litigation battleground. That will almost be a given. Even for members of the public, that is highly likely to be a very poor battleground. That is because of things like the Occupiers Liability Act. So for those of you that run businesses that still are having members of the public, such as certain key areas of retail or maybe even face-to-face logistics, there will be occupiers liability requirements that will establish that duty. The breach of the duty will probably be the main area, and we're likely to see arguments over what the employer did or did not do in line with government guidance being the main criticism there. There will then be a second battleground for defendants, that if the claimants get over the first hurdle of that, sorry, the second hurdle, I should say, that there has been a breach of duty, and we'll talk more about that, how that could occur. They will have to prove that your breach caused their illness, and for today's purposes, we're specifically looking at your breach caused them to contract COVID-19. That will be a very tricky ground. We all know from the press how infectious COVID-19 is. So proving it came from your premises as opposed to catching it on their commute or a family member who's been ill is going to be very tough. There is one possible workaround that may come here, which is akin to industrial disease claims in the asbestos sector, which is where the courts have rendered those conditions what's called indivisible. What that means is the claimant will not have to prove that the COVID-19 definitely came from their workplace, just that it was a possible exposure area. They will still need to provide evidence of that, but the court may hold the view of saying, yes, they could have got it at home, they could have got it on their commute, but they could also have got it from work, and it would be unfair of us to expect the claimant to know forensically where they got it from. That will obviously be problematic for defendants. And then once they've satisfied that third hurdle, there will be the fourth area, which will be that they've suffered damage and loss as a result of their illness. Now, again, there's a slight difficulty here for claimants in that, not to belittle the symptoms of those that have suffered appallingly under COVID-19, there are a number of cases, I believe the most recent stats are around 80%, where people are asymptomatic, and the number keeps fluctuating. It varies from country to country, but obviously you can't claim if you've not been, or you can't claim a significant amount, sorry, if you've not suffered any harm yourself. So there may be difficulties for claimants there who, even if they prove that the employer has breached their duty, they contracted COVID-19, unless they can show significant injury or loss financially, their actual claim will be almost a paper claim saying, yeah, your employer is liable, but actually the award of damages is either negligible or nothing because there was no real loss. In terms of just the final box of where do we think claims could potentially be addressed against employers under the employers' liability legislation highlighted above. Clearly, breach of duty may come from the fact that they will allege that you have failed to discharge duties in relation to provision of PPE. So we're seeing quite a few clients making inquiries around face masks, whether they're necessary. Hand washing equipment and stations obviously is an important factor for those of you that are still in work or still in the workplace. Social distancing and enforcement of social distancing. Again, these are all measures that I'm sure anyone who's watched the news in the recent weeks will now be more than familiar with as terms. These will be things that employers are expected to implement and enforce. So obviously breach of any of those wouldn't necessarily be a finding of liability on itself, but I can see those being lent on heavily to establish that breach of duty. Obviously, the claim itself for getting COVID-19 will be the main crux of what they're actually seeking damages for. We might also see some other areas around anxiety and stress or mental anguish. So these are for people who haven't even contracted the virus but are so worried about getting it they've suffered severe psychological harm as a result. These again are very tough areas for claimants to prove on. The courts have been relatively unsympathetic to claimants around those particular heads of loss. It normally needs to be something pretty extreme to be able to be successful around anxiety and stress and mental anguish when you haven't actually been physically harmed yourself or witnessed someone almost directly next to you suffering that physical harm. And you're probably getting from this already that there's going to be a lot of uphill battles for claimants here, but this is aimed at still being prepared in case these claims start to come through. Other areas potentially around musculoskeletal issues, which is for those of us that have all been sent home to work from home. There may be new working environments for people. They might not have home environments that are appropriately set up for using display screen equipment. That's been the main focus, in that working from home for some of us will have been a regular occurrence, and we'll have workstations that we're used to using. We may have even had employers who've put us through the display screen equipment tests already to make sure that our setups pass muster. But for a lot of us, will have been sent home and won't have those assessments in place. And what's tricky here is that historically the HSE haven't required it for temporary based home workers. The question that's on everyone's mind at the moment is this going to be temporary or much longer term isolation? Again, that's something that no one can answer at this stage. So prudent employers or more cautious employers may wish to start making sure they've got suitable display screen equipment assessment or evidence of it already. And we'll come on to it on the later slides that there is some very helpful guides from HSE. I don't anticipate you needing to do a huge amount of work, but having some basic paperwork in place should be hugely beneficial if claims do come through. And then lastly, before we move on to the next slide, mental health and wellbeing issues. Clearly working from home is very different, and also people who've been furloughed, again, clearly a very different work environment. That's going to put all sorts of pressure on people psychologically. So this is separate from the anguish over I was worried I could have got COVID. This is simply a case of I'm not worried about COVID, but I'm now working from home, I'm isolated, I'm stressed, I have all the same production targets, but I don't have the resources of my colleagues around me. It can even be things such as employees who traditionally have needed more management support than others, and as a result of the home working environment, they've now had that support withdrawn, and they start feeling isolated and abandoned again, and that can then lead into other conditions around depression and anxiety and exacerbate those, and they may seek to bring claims on the basis that the employer failed to support them in light of those conditions. So if we move on to the next slide, I want to just deal with two specific scenarios at the moment. I will deal with home working, and I'm going to talk about prudent measures in a more general sense. The first thing with a home work environment, now that, as I said, we may be looking at this less under the temporary exemption that the HSE allow, as the Health and Safety Executive, sorry, for those that aren't familiar with the acronym. a risk assessment around home working. Now, I think for those of you with thousands, if not more employees, obviously a personal risk assessment for every single one is not going to be practical. So I would imagine there are no major issues with using a sort of a template, generic home-based risk assessment. You may want to make certain exceptions if you know a particular employee would have specific requirements themselves, but generally you just want a general risk assessment showing that you've considered the risks that may be faced by home workers. There are very useful templates on that. Again, on the HSE website, you're more than welcome to reach out to Marsh, and we have a website that you'll see on some later slides that has a variety of help to help you identify what risks you should be considering in that risk assessment. Remember that some of this will be obvious to you if you are a health and safety professional, and you may think, well, we've documented some of it, but do we need to document every little detail? The idea behind these risk assessments is more to act as evidence many years down the line. So think about this not in the context of, I don't need to write that down because I know that's the case right now. These claims will take, in my estimation, at least 2 to 3 years to go anywhere near a courtroom. And that is probably a wildly optimistic expectation of the timeline. So what I want you to constantly bear in mind as well is that you could be having to explain what you did and how you managed home workers 4 years or more down the line, which I think will be very, very tricky for a lot of employers, particularly as by that point, people may have changed jobs, organizations will have changed. So these documents are going to be absolutely essential in the years to come. And that's why, again, they should be kept somewhere safe to make sure that they don't get lost. A particular issue, as I've already alluded to, is around display screen equipment. And if you Google DSE by the HSE or DSE from the HSE, that takes you again to a very helpful 2-page summary. And this is what I was saying before, is that I'm trying to make sure that everything we talk about today is practical. The HSE have produced a very good 2-pager. It's visual, so it can be sent to any employee without issue over language barrier or any worries over the understanding that they are not health and safety professionals. That document should provide a good guide to make sure that they have set up their workstations appropriately. And it's also set up that you can tick boxes, and then I would expect employers to have that document returned to them, kept on a file somewhere, and that way if claims do come out from that individual saying, you put me at home, you didn't provide adequate equipment, and as a result I've suffered some sort of musculoskeletal injury, we could refer to that document and say, well, we asked you to fill out your own assessment. Clearly it's not reasonable to expect the employer to send representatives out, nor would it be safe to do so in the current environment, to do home assessments live and in the flesh, as it were. I would imagine, or I said I'd like to hope, that the courts would take a pragmatic approach and accept that sort of self-reporting mechanism for a DSE assessment. That said, it's more than welcome if employers want to ask their employees whether they need specific equipment, such as chairs, keyboards, extra monitors, that kind of thing. But again, I have to be realistic. Not every employer is going to be in a position to do so. And I think it would be entirely surprising from a litigator's point of view to see the courts expect that, bearing in mind what the resource requirement of that could be for those of you with large numbers of employees who work from home. In terms of just some practical advice to give to your employees about the home working situation, obviously working from home may carry insurance issues or cause insurance issues to arise. They should probably alert their home insurers to the fact that they are now working from home. It's one of these cases where we can't predict whether that's going to have any impact on their premiums or not. I imagine it wouldn't, but I don't want to promise that. But essentially, it's to highlight the risk that some employees may now be having increased amounts of work equipment at home. Insurance companies will be wanting to know that that equipment is safe or that it's PAT tested, etc. But again, informing their household insurers would be a prudent step in relation to that. One of the points again is that the guidance is constantly changing, and again I'll refer to this on a later slide. Part of the problem at the moment is anything that's advised last week could be out of date this week, so keeping a close eye on what the government guidance is related to, particularly related to home working, and again the HSE put out good advice on that, is going to be important. And we'll talk a bit on the later slides again about having a active working committee around COVID-19 to keep on top of the guidance that comes out. In some cases there is very specific guidance for particular industries. And then lastly, on the kind of relating to the left-hand slide about home working here, remember that it is home working. You are at work. So if employees become unwell or have an accident that could be attributed to a kind of a work-related environment, they should be reporting that. They should be getting in touch with someone just as you would do in the workplace to make sure that you as a company are aware of it. We'll see on one of the penultimate slides about there are requirements under the reporting of injuries, dangerous occurrences and diseases regulations around COVID-19. Now, obviously, if you as an employer are expected to report to the HSE instances of COVID, you need to know that your employees have suffered from it. So you need them to tell you. And again, for home workers, it should be mandated that if they have accidents that are related to work-related activities, they should be alerting HR or their line manager or whoever your normal kind of accident reporting channel would be. In terms of the mental health side, clearly, again, as I mentioned earlier, the working from home model will not be well suited to every single employee, and certain employees will need extra support. Now, we've set up some practical advice on the right-hand side of your screen around mental health about certain things that you can do. The important thing here is to make sure that you have got documentary evidence. So this could be a group-wide email of things like notifying employees what support is available. So for those of you that have trained mental health first aiders, maybe a quick reminder from the mental health first aider team, who they are, that they can be contacted, that any time is a good time. It should also probably be worth reminding employees that it doesn't necessarily always need to be work related, that these support resources are brought into action. Again, working from home can highlight a number of other kind of hot button stress factors, such as their own personal environment, possibly just the environment of never actually leaving the house. So having the avenue there to vent these frustrations and making sure that you've got the evidence that you've signposted employees to these resources, that could be very valuable later down the line if an employee starts alleging that they were not supported at this time. Similarly, those of you with employee assistance programs, a quick email round to the organisation saying, look, these are the resources, this is the phone line, this is the email channel that you can get in touch with to get help if you need it. Then that, again, I think down the line is going to be beneficial should there be claims around mental health and well-being. If we can move on to the next slide. So in terms of sort of overall actions, we've got about 11 points here, and I'll go through each of them. But in terms of the wider strategy, I've touched on one of these already, which is having a sort of a COVID committee. And this might already be your incident response team, that looking at this from a business continuity respect. But as I referred to earlier, the advice is changing rapidly here, and in some cases, the government advice has done an almost complete U-turn. So what will be absolutely crucial, bearing in mind, as I said earlier, that we could be looking at these events 4 years distant from now, you will want to know with absolute certainty what the advice was on any given day and what you did about it. And so what we've suggested to a lot of clients is simply keeping a written timeline of the date the guidance was issued, what your response was, what the target date for implementation of that action was, and it might take longer if it involves acquiring things like new PPE or different spec PPE, who is going to be responsible for that, and latterly, what the actual completion date for the advice was, of course. So that again, will be absolutely crucial, showing that you have taken a reasonable response to the issue. Again, my experience of litigation over many years is that claimants are not always charitable in the allegations they make. So they will allege a lot of the things that you did that you didn't do. And the difficulty, again, from my experience in personal injury work, is that employers often did the right thing at the time, but they failed to document or evidence in a way that several years down the line that it would stand up in court. So a nice clear document about what you did, when, who did it, that will be extremely useful. Not only will it back up any account from the organisation that they did take reasonable action, if you assign things like the nominated person to a lawyer, that will instantly identify a good defendant witness to then call, if necessary, to a trial. Another point I've said to several clients is keeping records around key decision processes. Some of the guidance is very much advisory, or it puts the ball in the employer's court as to how to act. So there will no doubt be a lot of judgment through hindsight of that was the right or wrong decision to make at the time. My personal view here is that I would be disappointed to see courts judge with the benefit of hindsight that an action was wrong, unless it was so obviously wrong and flies almost completely in the face of government advice. So I'd have to suggest, you know, something like a blatant breach of social distancing and failure to provide PPE or hand sanitizer in a very confined workspace environment. Clearly, in those situations, you could see how the court wouldn't have to struggle that much. But if you can demonstrate you followed the government advice and that any decisions you made were made with a sound basis, and again, the important point is evidencing how did you get to that conclusion. So this could be a meeting minute where it said, this is our problem. It might be a case of, this is our problem. We have 2 employees. We cannot implement social distancing. We have 2 options, essentially: shut the business down and don't work to avoid any exposure, or carry on but implement something else. You want to say, well, we can't shut the business down because it's a critical support business, or it may even be a case of there's no need to shut the business down. We can carry on with business as normal, but we can implement these measures which we think will provide the right level of safety and are in line with government advice. Recording something down like that through a meeting minute will be extremely valuable again later on, because what claimant lawyers will probably try and argue is that decisions were made almost purely on a profit basis. You didn't shut your business down because you wanted to keep making money. You didn't really care about the well-being of the employees. If you can dispel that by saying, no, there was a clear thought process, we wrote it all down at the time, that is our defense for it. You know, that is our justification for carrying on as we did. And again, as I've alluded to, your COVID-19 committee should keep a close eye on what comes out from the Health and Safety Executive, Public Health England and the government's own COVID-19 website, and just make sure that when something changes, the documentation we've talked about, your COVID-19 risk assessment, your policy on how you're going to keep working, make sure nothing then becomes incompatible with that. And that's going to be probably the tricky part. Remember that you'll be given a period of grace to implement changes, but again, you know, it's that point of trying to keep on top of the advice and listen to your employees as well. I've already seen some good inquiries from clients who've come back saying, well, my employee's saying this, what should I do? And we've been able to look and say, do you know what, they haven't got a bad point. It's worth taking on board. Let them air that grievance or let them air that point of view. If you listen to them and do what they say, they're less likely to feel like they're uncared for and you're just trying to get the most out of them, and that may hopefully allay any concerns they have. If you don't do that and they become antagonized, that in my mind would make them more likely to go and see a claimant lawyer. And again, I've already touched on the risk assessment point here about evidencing your compliance via a risk assessment. And we've highlighted in the 6 bullet points on that in that box some potential areas of risk. Now, what's difficult for me to do in the confines of this particular seminar is that it's very hard for me to know all the risks applicable to your business. Clearly, we've got a number of attendees on today. You'll all be doing very different things. You'll all be working in very different environments. I've highlighted 6 key risks, though, to think about. Your risk assessment should highlight each of those risks, and your control measures should be extremely specific. So, for example, if you're having to work in the warehouse environment still, picking that as an example, and you've decided to implement social distancing and sanitization stations, the control measures should be very detailed. Where are those sanitization stations? The social distancing you put in place, how is that enforced? Because if it is just generic one-liners in the control measures, there is a danger that, again, 4 years down the line, everyone forgets what the real arrangements were, or you give the claimant lawyers room to exploit the fact going, well, you said you put hand sanitizers in, and you did. You put 2 in at the entrances, but none in the actual workplace where the employees had to spend 90% of their time. And again, just quickly there on box 3 is Marsh's COVID-19 Resource Centre, which has a lot of helpful advice in addition to what we can provide today. So on to our next slide. Again, PPE provision is clearly a hot topic at the moment. I think my main point I want to raise on this is that I appreciate a lot of organisations are facing difficulty getting hold of PPE. In those scenarios, record what efforts you made. So keep emails, keep telephone notes of telephone conversations you made to suppliers, and keep them on a file. If you are unable to provide PPE to your employees, but you've made reasonable efforts to do so, it is hard to see in the circumstances what else a prudent employer could do, and those kinds of records again will just add weight to your defence if it is a case of we tried but we just could not get hold of it. Where you do issue PPE, please keep records of who it has gone to, that you have provided training. So, for example, face masks. You know, how do people put those face masks on? That is absolutely crucial. It's very well documented that lack of a good face fit completely negates a lot of the face masks efficacy. And again, some sort of record that people have received that instruction. Once again, the HSE website has a very helpful face fit guidance note that is easily available. It covers FFP3 respirators, but the principles apply, and it wouldn't do any harm sending out to all employees you've asked to wear a face mask. In terms of identifying vulnerable categories, this is things like due to age or underlying conditions or pregnancies on there as well. Make sure you've identified those workers. They might be in that category where a generic risk assessment will not be sufficient. You want to carry out maybe a personalised risk assessment for that person. You may have to flex what your working arrangements are for them, and making sure again that you've documented that through discussions, likely with HR involved, ideally email correspondence to prove that you have offered them alternative ways of working, and ideally that they have responded to you saying, I am happy with these new arrangements. Again, that email with them confirming that they're okay with how things are could be absolutely crucial. So, subject to the fact that at a later date they may allege that you did or did not do something to support them as much as you could. In relation to illness reporting, again, the current COVID-19 symptoms are on the websites listed in point 6. Clearly, if anyone displays any of those symptoms and you are still at work, so this is talking about non-home working, they need to be told to stay at home in line with the government advice and guidance. Similarly, if anyone in the household has had similar symptoms, it would be prudent to encourage employees to report that and make sure that they do not bring COVID-19 into your workplace and run the risk of infecting co-workers. There are a couple of concerns around this, of course, which is obviously the symptoms do seem to change a bit. Well, as I said, the website there has the most up-to-date NHS symptoms, and there is potentially a GDPR concern here. At the end of the day, you can ask the question, if your employee says, I'm not telling you anything about my health conditions, I wouldn't want to get you in any trouble with the Information Commission Office, but there may well be arguments around the permitted grounds for processing data for obtaining that information and doing something with it. But again, we possibly are going into other territory outside the scope of today's talk, and I'm conscious of time. One point that is really important though is point 7. All the measures you put in place, enforcement will be absolutely crucial. In relation to industrial disease claims we've seen in the past, that has often been the chief failing of organisations, and that's things like if you issue face masks, if that is what you've decided to do, you have to make sure that employees who've got them wear them. We've seen this in relation to noise-induced hearing loss, where hearing protection was issued, but the claims were all based on the fact that employees routinely flouted the rules. Similarly, if you employ social distancing and there is an employee who does not take that seriously and may even take delight in the fact of trying to get as close to his colleagues as possible to upset them, behaviour like that clearly needs to be dealt with via HR. It may be a formal warning the first time, but possibly something more extreme, again, per your own HR policies, if people do not adhere to these rules. And again, that is to protect you in the event that employees who are the victim of these pranks, or employees who have to work with people who do not use their PPE properly, they try and say, yes, company did put stuff in place, but it was never enforced. And if we come on to my, I think, final slide for the advice here before we take some questions. I've already covered point 8. Again, the advice is constant every day. I check myself, and I obviously keep myself appraised of the 5 o'clock government briefings to see if anything significant has changed there. I've talked about documentation. Again, it's going to be absolutely crucial. You write down everything you did or have some sort of document to show what you did. And I said the risk assessment is going to be a crucial document in that. I've talked about there, I hesitate with the pragmaticity of this, but it's CCTV and photographs. So if you set up, for example, sanitisation stations, it may not be the worst idea to take a quick picture of them to show that they were there. The reason for that, again, right now, it might sound ridiculous, but in 3 or 4 years' time, you may be faced with significant numbers of employees denying the sanitisation stations were there, denying they were well stocked, denying that they were suitable for the number of employees, and that photograph could be worth its weight in gold. But again, it's down to constantly recording things via your control measures in the risk assessment and saying what was there, and then making sure that people restock these stations as they become depleted. So my penultimate point here is about RIDDOR. Under the reporting of injuries, diseases, or dangerous occurrences regulations. The HC have issued very clear guidance. RIDDOR applies to COVID. The difficulty is, and at the moment, that the guidance is not the clearest, I'm afraid. It says in the first limb, an unintended incident at work has led to someone's possible or actual exposure to COVID. That's probably unhelpful, probably for 90% of the employers out there, because unless you work for or working in the NHS or directly connected to it, your knowledge of whether someone definitely has COVID-19 is probably fairly limited. And the HSE's own example was a medical professional accidentally exposed to COVID, a COVID-19 positive patient. Well, again, that might be useful for the NHS, but for the average employer, that's not great guidance. It's not a situation I would have thought most of you will find yourself in. The only scenario I was able to envisage myself would be that if you are somehow linked to the supply chain or waste management chain of a healthcare provider, and one of your workers is exposed to dirty PPE or used equipment, used medical equipment, that could potentially provide a risk if there's been an unplanned exposure there. The second limb is slightly more applicable to all employees, but again, unfortunately, the HSE's language has been rather woolly here. They've said a worker has been diagnosed as having COVID-19 and there is reasonable evidence it was caused by exposure in the workplace effectively. Now, the problem we've got here is getting diagnosis is next to impossible due to the lack of testing at the moment, and the HSE have not yet offered any guidance on what a diagnosis is. Lastly, the reasonable evidence, again, what is reasonable in terms of someone has got COVID-19, by some miracle they've been tested, it's all confirmed, so we definitely know it's COVID. How do we know that's workplace related? It's going to be very, very hard unless you can point to a serious outbreak amongst your employees who've all worked in a particular production cell or particular area of the workplace. I suggest that's going to be quite hard. And all we can say at this stage is the lawyers are lobbying the HSE for greater clarity on this. And in addition, if there is any confusion, pick up the phone to the HSE before making the Riddle report and see what they think. That might be naive and optimistic, because the HSE may not answer or may not give you a much better answer than what they've already put out there. But again, I'd rather that my clients checked than didn't report and have the HSE come after them. Last point before I wrap up. You're still running, for those of you that are still running businesses because you're an essential industry, you are still unfortunately open to the risk of traditional employers' liability accidents. So nothing about the current situation alleviates the need to investigate incidents. And again, there is a danger that if you don't do so, you may see completely unrelated to COVID, but claims as the result of workplace accidents with people seeking to take advantage that they know you didn't look into it. Clearly, principles around social distancing, how you talk to people may have to be over a telephone conversation rather than face-to-face, but please don't take your foot off the gas in terms of the way you deal with incidents and investigate them to obtain evidence after the fact, because again, that lack of evidence could be seriously problematic at a later date. I'm conscious I've overrun slightly there and I've gone through it quickly, but I will hand back over to Charlie now to do a quick Q&A.
Thanks, Alistair. Before we turn to audience Q&A, I just want to spend a couple of minutes going over how our audience, how Marsh can actually help our audience, and more broadly, how Marsh & McLennan is working with our clients around the world. So firstly, we bring all of the resources of the organisation to bear to help clients manage impact and to recover from the outbreak. What that means in practice is that we have colleagues working with clients on how their various forms of insurance coverage can respond to the pandemic. We have claims advocates who are currently working through with clients how their particular claims can respond. And finally, we've got risk consulting teams who are working with clients directly, either embedded within their teams or on an outsourced basis. We're happy to help you in any way that we can. So a couple of questions then in the last 10 minutes that we've got here. Alistair, firstly, a few questions have come in. I think it's worth just clearing this up around what timescale is considered as temporary for working at home.
This is the problem. It's never been defined. And again, I can see the references, Charlie, I think you may come on to about the ABI. It's not clear, unfortunately. There is no set time frame. It is simply called temporary. Whether we'll be able to stretch that out for however many months that people have to work from home from or not, I'm afraid I don't know is the answer. At this stage, it's a case of I would feel that employers may want to consider how they can do the fairly simple process, I said, of sending out something like that, DSE from the HSE document, to try and sidestep some of the concerns there may be if it's around the DSE type risk. But aside from that, I'm afraid there is no concrete answer on that at the moment.
Great. I realise that's frustrating for people, and similarly, a number of questions here around the ABI guidance, around exactly what people do or don't need to do in this circumstance. Now, you covered this a little bit earlier, but maybe it's worth just explaining this one again. Yes,
so I suggested, I think in the talk that reminding employees to contact their insurers. I mean, clearly some insurers and the ABI put out advice already. I talk about this from myself, my personal perspective, as a risk-averse person. So by all means, I believe certain insurers have put up on their website, you don't need to call us. We're okay with you working from home. That's fine. It may be better then to qualify that advice to employees. Say you might just want to check your home insurance policy, your home insurance provider's website, just to see what they've said about it. As I said, I talk about it purely from a completely risk-averse person myself, that if I was to look at my own home insurance website and they said absolutely nothing about it, I've got my insurance contract in the drawer here and it says I need to alert them until I'm told otherwise. I don't want to invalidate my home insurance. And again, regardless of guessing what the ABI say, at the end of the day, my contract is between me and my home insurer, and I'd rather, for the sake of a phone call, just make sure I'm in the green on that.
Thank you. So 2 questions here around furlough. Firstly, are employers responsible for mental health of employees if they've been furloughed? And secondly, is there a potential for them to receive a reduction in premium for the same period?
Well, the reduction in premium one is probably outside my area of expertise, I'm afraid. That would have to go to likely one of our broking team, but we can try and look into that and get a response. In relation to responsibility for employees that are furloughed, my view is that as long as the contract of employment remains in place, because furlough obviously being distinct from being made redundant and exited from the business, there is potential there for that liability to remain. I have to say there has been very little case law around claims for mental health full stop, let alone while subject to furlough. But as far as I can see, if the employment contract is there, we go back, we think about that, what was on that first slide, is there a duty of care there? Well, if the employment contract's still there, they're still an employee, I believe. Could you have breached that duty by not looking after them? Absolutely, if you don't reach out to them or at least let them know there's these resources available. Could that breach cause loss? Of course it could. And could that loss be significant enough to bring a claim? Again, of course it could. If these people fall into a deep depression or anxiety or any other psychological condition that means they cannot return to work, there could be a significant claim for loss of earnings there. So I don't think the furlough changes the employer-employee relationship, I'm afraid.
Thank you. There's also been a question here around whether an organisation could be held liable for employees contracting COVID-19 whilst working from home.
So the issue there would be, where does your breach cause that COVID-19 to be contracted from? And I think I'm trying to think about it creatively here, is that you could say you forced me to work at home and one of my housemates got it, and that was where your breach was. I wanted to come into the office, but I think as an employer you would say, well, we have to send you home because it's more prudent for us to protect all of our employees and send everyone home rather than have some come in and some not, and risk exposure that way. So you're kind of in between a rock and a hard place. I would suggest, or I would speculate, I should say, that it would be very difficult for a claimant to allege their employer had been negligent by sending them home in the current conditions, bearing in mind the government advice, and that they then suffered the loss associated with contracting COVID as a result of some home-based vector, I suppose. I think that would be very, very tough to establish. So in terms of, quick answer to the question of could you be held liable, it's entirely possible, but I think highly unlikely. But again, we are working a little bit with speculation here to see how the courts will treat these claims, but that's not very high on what I would worry about, I would have thought.
1 or 2 questions here about returning to work. One saying, for employees who return to work voluntarily or against advice, should they sign a waiver or disclaimer? A couple of others on the same theme, though.
Okay.
When we move to a new phase and shielded workers are allowed to return to work, how do we protect them? Yeah. And should employers provide PPE, including face masks for staff?
So I'll deal with it in 2 parts if I may. So the disclosure, the disclaimer and waiver point, you can do it. Disclaimers and waivers are a psychological tool, not a legal one. So you can't hide behind a waiver if you have failed to comply with your duties under the law. Similarly, if you do comply with all your duties under the law, well, actually the waiver should be redundant, because why do you need a waiver? To exonerate you if you've done everything right, is the line of thinking. But it might be useful to make some clients look at doing that, or some employees to look at doing that, because it will focus their minds. It will, I said it's a psychological tool. It can make them be of the view that they've signed that and they're happy to come back. There's a flip side to that. It could also make them think, why is my employee asking me to sign this? Is there something wrong? We always have that sense of self-doubt when we're asked to sign a waiver. What I would suggest would maybe be a more useful tool would be, so again, bring on to the second point you asked, Charlie, is that in terms of people coming back to the workplace, a very clear communication of information via something in writing to say, you are coming back into the workplace. these are the measures we have put in place to protect you. And it might be, this is the PPE we have provided you with. You will be expected to adhere to those measures. You will be disciplined if you don't adhere to those measures. And again, having their management monitor compliance with those processes. But it may be more useful to look at it in that point of view, rather than the waiver saying, I hereby forgive my employer for any harm I may suffer, rather than say, this is what we've put in place, this is what you're expected to adhere to. If you've got queries, questions, concerns, this is who you can address them to. And working on it on a more two-way line of communication, rather than that you've signed your rights away point of view. And sorry, just dealing with that last little limb of, should we provide PPE? That is going to be heavily dependent on your industry. Again, there is very good guidance on the Public Health England website. It separates various employers out into a number of tables. There's table 1, 2, 3, and 4. And table 1 is for high-risk medical professionals. So this is your surgeons and your doctors dealing with known COVID patients. It goes all the way down to table 4, which is pretty much every other organisation outside of a clinical setting. The requirements for PPE, such as face masks, are very low at the moment. There's no specific requirement for it. But again, out of an abundance of caution, if you find yourself able to provide things like face masks and various other PPE, that may be advisable, and it may be a decent risk mitigation method. But again, it's about making sure that when you bring people back into the workplace, you are adhering to the government guidelines and you're able to evidence you've done that. And I think the biggest one at the moment really is social distancing. So trying to keep people 2 meters apart in office environments, that kind of thing. But the PPE part, you're going to have to look at the individual government guidance for your industry, because it is very variable and it is potentially changing on a daily basis.
Thank you, Alistair. We'll try one more question, which if we can do very quickly, we'll try and finish on time. A very interesting question here. I've asked an office worker to work from home, but they've returned to the office work. Could I be liable for due to a lack of enforcement, or are they now working at their own risk?
So if I've answered the question, that's someone you've told to work from home and they've effectively refused and come into the office anyway. That's an interesting one. I would suggest that, yes, I think there's a risk without the enforcement. There could be a problem there, because what you have there is effectively a willful disobedience to follow the procedure. I think what a constructive way to approach that situation would be to try and discuss with that employee why they are refusing to work from home, and is there an accommodation that you can make that will encourage them to transition to working from home. If it is not possible to do that, and again, there are concerns about antagonizing the employee by instituting a formal disciplinary process, again, depending on your organization's resources, you may want to look at whether you can have them work in the office subject to very strict controls. And again, the former litigator in me would say I would get their consent in writing that they are then happy with those arrangements and accept that. I suppose the difficulty comes if I'm envisaging a scenario where they are literally the only person in the office. The concern that you could have is if they bring something in as an infection themselves, or you've got other people who are vulnerable who are coming into the office, and that's how you've chosen to work. There could be problems there. So I think, I think I think in a nutshell, the shortest way to say is, look, try and identify what their grievance is, and can you get them to work from home subject to that grievance. If you can't, actually thinking about it, I think you've got to look at they're breaching a workplace instruction, because what would worry me a little bit is if another employee sees that person getting away with breaking the rules about not working from home. If you then try and make employees wear PPE, well, why should I stick to that rule? You clearly aren't following your own procedures. That could be problematic.
Alistair, thank you. I'm afraid we don't have any more time. We've had a large number of questions today, so thank you for everyone who submitted a question. Thank you everyone for joining us, and thank you most of all to Alistair for leading today's discussion. As a reminder, this was the first in our risk management webinar series. You can sign up on our events page on marsh.com/UK to register for the upcoming webcasts. We will be sending out a replay link and a link to the slides that Alistair was using today. Please don't hesitate to reach out to your Marsh representative for any questions or concerns you may have, or if you had a question and it wasn't answered today, please again reach out to your Marsh contact and they'll make sure that question gets to Alistair. Again, thank you all for joining us today, and we look forward to you joining us again on Friday for the next part in this series. Many thanks.